Thank you. I forgot about that. I don't know where he went yesterday to get to the. Morning, Mr. White. How are you? We're better than we were yesterday. I know. I saw that. Pull down again. Yeah, they're reprinting all the papers from yesterday. Yes, ma'am. Oh, it's awful. I had to reset everything from yesterday to today, and he hasn't done the two-step verification yet, so I'm sitting here waiting on that. And we didn't have any internet yesterday, so I had to do all the dockets this morning, so. So how are the babies? When do they get to come home? Oh, that's good. That's tomorrow. Mm. Mm-hmm. But once he does this step, it automatically comes up, right? Okay, because I'm still at the two-step verification, so. But oh, I think he just did. Yep, he did. Okay. So then. Oh, okay. Yeah. Let me go get that docket. Hang on. I mean, that's canceled since. Okay, so it came back to YouTube. And now, but I don't see us. And I don't see the dashboard or anything. No, I was already in Edge. That's where I went to do the two dot things, the two verification. Okay, so now I see the courthouse on YouTube. Okay, I'm not on the studio. It says YouTube, that's all it says. He'll be here in a minute. He did it yesterday when we did that one downstairs. And I did criminal because. So after the two-step verification, the channel dashboard did not come up. I don't think these, things are going straight through. I mean, it's not, the instructions aren't. Okay, YouTube Studio. It just says processing, please wait. We got it about 8:30 last night. We had gone to Glendale to a hotel, but it just keeps saying processing, please wait. If he's saying something ugly in the comments, it's just too bad. All right. That's good.
Doing okay this morning? I need to say. Oh, yeah, we're worship. Don't know how you're doing, but so. I do a lot of things that say, I do, yes. No, yeah. Yeah, my sister, her. She did not only all the road. The others, and they'll bring some jobs with that, but. Ours, it was out. Watchable. Prosecutor here, I think. Back here. I'm not going to be back there. Well, yeah, well, that judge, right, certainly, it's like freestone, limestone, it's, you know, some guy that follows off part. What goes yeah, and that's it. Yeah. Yeah. Since I do all. Yeah. Run in. Very good. There you go.
All right, good morning. Welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Anthony Collard, Anthony Dale Collard, Kyle Holland, Mark Lemon, Mark D. Lemon, Kenneth Nash, Stephen Pickren. I have a note for the state that Mr. Pickron was sentenced to TDC for 5 years in Dallas County in February of 24. So we'll recall that and discuss that case. Jennifer Zanella, James Godwin, James Wesley Godwin. Is Mr. Hawkins here? Was he here yesterday? Did he show up yesterday? You know, I want to contact Mr. Hawkins and see if something's going on. Ricky Serta, CR 22371. Mr. Schmidt filed a waiver of arraignment. That's been accepted. Do you know, did y'all determine a pretrial date? Say again.
June 13th.
All right, court setting Mr. Serta for pretrial June 13th. And I don't believe that Mr. Serta has signed his conditions of pretrial release, so he'll need to do that within 10 days. Edward Drummond, Donald Ellis, all right, waiver of arraignment filed, pretrial set July 2nd. Jeremy Estridge, Jason McDonald, Jason Wayne McDonald, all right, we'll call that one back. Keith Meredith,
Here.
Joshua Nowak, Evan Page, Robert Wells. I see that Mr. Wells is in the Zoom waiting room. We'll recall that case. Cynthia Warrington, Cynthia Joyce Warrington, Preston Wilson. Say again. He's in federal custody. Wayne Wingo, Carrie Sanders, Christina Swope. Did you say here? Daytona Blue, Aaron Ross, Jesse St. John, Wesley Ball, Jose Funes. Those are at 11:50. I've seen all of those clients. Okay. All right, let me say to the room, I'm sorry for the power outage and everything yesterday and having to reschedule to today. I know that may inconvenience some of you. I apologize for that. If there was something I could have done about it yesterday, I would have. So I'll move as quickly as I can today to get you back to jobs and home. We have any attorneys that are ready? Mr. White? Wesley J. Ball, CR 23232. Mr. Ball is set for pretrial.
Your Honor, we don't have anything as, 5 hours. I do need to, not close, say.
You may. All right, court sets Mr. Wesley J. Ball for docket call hearing on Thursday, August 1st at 9 a.m. And once Mr. Ball gets his notice of setting, he's free to go. Put it on that podium there, just face them. We'll pull that one out there and face them. Thank you, Mr. White. Is that all you have?
Yes.
You have anything this afternoon? Enjoy your day. All right, Mr. Jeff White, you ready?
Yes.
All right. Who would you like to call first? All right, we'll just go down the list then. Daytona Blue, CR 23201. All right, Mr. Blue is set for a docket call today. Go ahead, Mr. White.
I think we should, offer that we would strongly consider. This is a case that involves, 6 other co-defendants. I believe the state has some desire to try to see, I can't get this all kind of taken care of within the same time frame, like about a week. Our situation is, I think we're the first one.
State.
Your Honor, I believe, most of the unique articles set to be resolved, within the next 1 or 2 dockets. I have no issue with sending it over to try and resolve them at the same or similar time.
So what are you telling me? How much time do you need?
Not tomorrow, but perhaps the next setting or setting after that.
I am going to be in court already on June 20th.
Yeah, that's an evidentiary day for us though. So I can't really afford to clog up my evidentiary days. If we're just going to do a plea or announcement. I've got June 13th or June 18th. I'm not sure how many we have set that day.
I will not be here that. I need one of those days, Thursday.
That July 2nd.
I think that would work.
All right, court sets Mr. Blue for docket call July 2nd at 9 a.m. Aaron Logan Ross. All right, Mr. Ross is set for pretrial in both of his cases. Go ahead, Mr. White.
Your Honor, I don't believe that any contested motions that I filed, we will probably ready to have a separate docket call. The only thing I would call to the court's attention is probably back in the last case. Might have some kind of situation.
State.
Your Honor, I can speak with this, but I do know what, at least As of a few weeks ago, Ms. Curry's intended off, but I think that there's that that's related to that.
All right, court will set Mr. Ross for docket call on Tuesday, July 2nd. And Mr. Ross, have you signed your conditions of pretrial release yet? Have you met with Mr. West? Okay, yeah, once you finish, you make sure that you see him, and when he tells you you're free to leave, you're free to leave. Okay. Jesse St. John? All right, this is cause number CR 2436. Mr. St. John is set for pretrial. Go ahead, Mr. White.
Your Honor, once again, I believe that the motions that I filed are not that spec. However, I would be asking for another pretrial on that. It's two of not the DVDs, but the things on the computer won't apply. But I still think that there's a very strong possibility we have this thing resolved by the next court day.
Are you going to get with the state to figure out the discovery issue?
Yes.
All right, court sets Mr. St. John for an additional pretrial on July 2nd at 9 a.m. Once he signs, he's free to go. Thank you, Patty. Mr. Wheeler, are you just waiting on paperwork?
Yes,
Okay, very well. Just let me know when you get that and we'll get you in.
yes.
All right, for the record, on page 2, the docket calls number CR 23-140 and 141, State of Texas versus James Wesley Godwin. Mr. Godwin was set for docket call today. The court's resetting that to June 18th. Mr. Hawkins is currently in Lubbock on a family law matter. And so I believe also he's reporting that Mr. Godwin undergoes daily radiation in Hunt County. So we're going to set it at June 18th at 9 a.m. for docket call. Mr. Schmidt, are you ready? No. Let's see. Let's just set him. You just set it for June 18th. All right, Mr. Nash, calls number CR 2271. All right, Mr. Nash, we set you today for status on hiring an attorney. I believe the last hearing we had, you indicated that you were attempting to retain an attorney. Can you give me an update on that? No, just tell me. Tell me what you've done.
I have not, paid an attorney, the last visit for the, your selection, went ahead and developed it.
Well, tell me, did you try to hire an attorney?
Yes, sir.
Well, tell me about that. Tell me about that. Go ahead. Who did you speak to, and are you close to hiring an attorney or not? Tell me about all that.
I called several attorneys, the attorneys, some of them were very rude, some cussing at me, so.
Well, who did you try to call? I need you to tell me what you did to try to hire an attorney.
Sir, so, I called, uh, talked to them about, what I needed to do, where we were, and a lot of them were so far into this. X amount of money, and this is what we have to have, and, out. It's several, no, actually, none of them had enough that I can.
All right, so how much money do you have saved up for an attorney?
They thought I costed everything, with the situation, this court case.
All right, have a seat and I'll call you back up in a little bit. don't have any notes on Anthony Collard. Anthony Collard, I don't think he's here, but, okay. All right, I'm just gonna tell you, there's nothing for me to write. Kyle Holland. All right, this is a sanctions court hearing and cause number CR 2291. Let's see, Mr. Holland, you were placed on probation in May of 2021 for 5 years on a third-degree felony offense of DWI third or more. Looks like you're currently delinquent on your community service. My notes here indicate that you're continuing to violate your community supervision by using THC. Dallas County's reporting your supervision's not going well up there. That's what they're reporting to my probation office here. Looks like you tested positive in March for THC in Dallas County, March 5th. What's IOP? All right, so before I give you a chance to tell me your side, if you want to, do you understand why you're here today, why you're in sanctions court, and why you're not locked up in the Van Zandt County Jail? Do you understand why you're here today?
Yes.
Can you tell me why you're here today?
I keep using marijuana.
Okay.
I think
And so if you can state it that bluntly and directly, then why are you doing that?
truthfully, I don't have a very good reason to do, Your Honor. I own my own business, so I keep prioritizing my time with that, of service. THC use is anxiety driven. It's not.
Are you self-medicating with THC?
I
Are you not seeking the care of a physician to perhaps give you something that's legal to possess and use for your anxiety and stress?
haven't done that yet. I've started speaking to an addiction counselor that I meet with once a week.
Go ahead, I'm listening.
I've been doing that for about a month and a half now. And we're trying to work on new tools to help me progress past that, get out of it, and step back and put that in.
So what kind of sentence did you receive in May?
It was the 10-year maximum, 5-year probation.
And so when you were placed on probation, I placed you on probation, correct?
Yes.
And do we have a discussion about if you violate the terms and conditions of your community supervision, what were possible consequences?
Yes.
All right, so you're very well aware of that. You seem like you're an educated man. Are you educated?
Yes.
Do you have a high school diploma?
No.
No college? And what do you do for a living?
I have
How long have you owned the restaurant?
this one for 4 years.
Is it successful?
It stayed above ground. But I think a lot of money off of
Are you married?
it. No, sir.
Have
Long time girlfriend.
any children?
No, sir.
You got anyone that you're supporting?
My
You said y'all been together for 15 years.
yes.
So, Mr. Holland, let me level with you. The purpose of sanctions court, the reason that we have this program is because we try to use it as an intervention tool to prevent people who may be violating, to prevent them from going to prison for using marijuana, for not doing community service, for not paying their court-ordered court costs and restitution, things like that on time. And so the purpose of sanctions court is to try to get your attention and put you back into compliance rather than just unilaterally filing a motion to revoke and putting you in jail and having a hearing and letting the court, decide if the evidence has been proven out that you violated your conditions of community supervision. And then if the burden is met, then for the court to decide, do I keep you on? Do I put you in jail as a condition of community supervision? Do I revoke your community supervision? Do I sentence you to prison? So there's a lot going on in your case right now. And this being your first time in sanctions court, I wanted to kind of give you the background of why we're doing it, because the probation department is well within their legal rights to just file a motion to revoke, ask the state to prosecute you and bring you back in here and argue to me that you're not a good candidate for probation. Are you a good candidate for probation?
I believe so.
That's not being proven out by what's in front of me now. You understand that?
Yes. On my option.
You're not trying to go to prison, are you? But every time you use THC, you know that you're making an argument for them to send you to prison. Every time that you prioritize anything above your community supervision, albeit but for your health and your survival, then you understand that you're giving them more arguments as to why you're not a candidate for probation. Do you want to stay on probation? Do you want to be given an opportunity to live up to the agreement that you told me that you wanted? All right, so this is what I'm going to do, Mr. Holland. I'm going to UA you today, okay? I'm going to sanction you 3 days in jail for testing positive for THC in Dallas County on March 5th. I'm going to reset you for another sanctions court hearing. And before then, I need you to pay. It looks like you're paying on time. You're paying your probation. Like you're paying your court costs. It really just looks like marijuana or THC and community service. And your intensive outpatient is not going to be successful. They've addressed this with you in Dallas County, correct?
Yes.
They cannot leave you in that program if you continue to use THC. So at this point, when you walk out of here today, you're going to have to make a decision. All right. And that decision is going to be, do you continue along this path that you're on using THC and not doing community service? Or do you make a change in your life to address whatever issues you have going on, stress, anxiety, whatever they may be, and make a determination of what path you're going to take? That path is going to decide for me what decision I make later for you. All right. So I'm going to have you come back on July 2nd. And this is what I want you to have done. I want you to have paid $60 to your probation office, $125 to your court collections. All right. I want you to work 20 hours community service. I want you to get back into compliance with your intensive outpatient. All right. And I'm going to let you pick 3 days in jail for you to serve. And those are going to be consecutive days. It's not going to be like every other Monday. It's going to be 3 consecutive days, but I'm going to let you pick those days so that you can work them around your work schedule. We don't want you to lose your job. We're not trying to make you lose money. And we want to set you up for success, not for failure. All right. But this is not going to be a revolving door of doing this. All right. You come back in here and you show me that you're complying. After a few months, I'll just put you back on regular probation and I'll stay out of your life. If you continue to use THC, if I continue to get reports that you're not successful in your your intensive outpatient, you're not doing your community service, then you're going to only be given so many chances before the state and the probation department decide that you're not a good candidate for probation. And then after that, it'll be between you and your attorney to convince the state what should happen to you. And if y'all can't come to an agreement, then you come to me and then I'll decide what happens to you. I don't know about you, but have you ever seen the government?
I've seen it.
You're looking at it. I'm the government. I'm a person, right? But I'm part of the government. Even I don't like the government telling me what to do. I don't want the government telling me what to do with my free time, with my money, with my kids, with how I work, with where I go to church, where my kids go to school. I don't want the government telling me any of that. And so I wouldn't expect you to want the government to tell you whether or not you're going to be locked up for 10 years. Is that sobering enough for you? All right. Because if you put me in the position, I'm gonna do my job. All right. And that job may be taking you out of society and putting you in a cell. But I don't want it to come to that. So I want you to go back here and meet with, we're going to have you sign a reset form for July 2nd. Then you're going to come back here and you're going to meet with Ms. Burns. She's going to give you the opportunity to look on your calendar, figure out what days you want to do. I'm going to sign an order for that. On that day, you're going to show up at the Justice Center here in Canton and you're going to do your 3 days. You'll show up with that order and a photo ID. Otherwise, they won't let you in. You're going to do your 3 days and then you're going to come back and we're going to see how things are going on July 2nd. All right. And then the very last thing I want you to do is when you walk out of here today is make that decision which way you're going to go. And then I hope it's the right way. And if it's the right way, then I want you to commit to it. All right. You're welcome. Make sure you get this. Hey. All right, come on back here. They're going to take a UA. We'll pick out those dates and you'll be free to go. Charleston, are you ready on Miss Zanella?
Yes, sir.
Miss Zanella, come on up. This is cause number CR 23, 133, 156, and 157, State of Texas versus Jennifer Paulina Zanella. You may, yes, please. Thanks, sir.
And Your Honor, I advise counsel that we potentially reach the 28th on the state line, for a date, the 29th, so I've changed the paperwork ones, but not the signature line on the two other matters at the back.
All right, Miss Zanella, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand. Make sure you speak up loudly and clearly so that I can hear you and so my court reporter can type down what you're saying, okay? Miss Zanella, your name is Jennifer Paulina Zanella, is that correct? And Miss Zanella, are you a United States citizen who reads, writes, and speaks English? In this case, you're represented by your attorney, Mr. Mark Ellison. Are you pleased with Mr. Ellison and the work he's done for you? Do you feel like you've had enough time to discuss with him your case to the point that you've had all of your legal questions answered? Is there anything about the plea agreement and this paperwork that you've read over and signed today that you do not understand? And where you signed these documents, that's your true and correct signature, and you only signed after understanding what you were signing. Is that correct? Mr. Ellison, do you believe Ms. Zanella is competent today? And do you believe that she's entering into this plea agreement intentionally, knowingly, and voluntarily? All right, Ms. Zanella, in cause number CR 23133, you are charged by indictment with delivery of a controlled substance or marijuana to a minor. That a third-degree felony does carry a range of punishment of not less than 2 years in prison or more than 10 years in prison, and also a possible fine not to exceed $10,000. I see the plea agreement in your case that you're asking the court to approve is that you would plead guilty to that crime, and the state would be recommending that the court not convict you today, but place you on deferred community supervision for 10 years. Also, asking the court to order a $2,000 fine plus court costs, reimbursement fees, and the state would dismiss 2 of your other charges, resisting arrest and possession of marijuana. That's part of that agreement. Is that the plea agreement as you understand it? And that's what you're asking the court to approve? All right, Ms. Zanella, then how do you plead to delivery of a controlled substance or marijuana to a minor? Are you pleading guilty to that crime because you are in fact guilty of committing that crime? Meaning you're not just telling me that you're guilty to get a plea agreement. You're pleading guilty because you are guilty of the crime.
Yes, sir.
Okay. And Ms. Zanella, has anybody threatened, forced, or pressured you to plead guilty? All right, the court accepts the defendant's plea of guilt at this time. Mr. Ellison, any objection to the stipulation of evidence?
No, Your Honor.
All right, stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Hang on.
Anything further from the defense? The court's going to review the evidence. All right, and state, is there any drug testing that's gone on in this case that restitution would be claimed?
No, Your Honor.
Okay. All right, then based on the evidence presented, the court finds that there is sufficient evidence to convict the defendant. The court, however, defers the finding of guilt based on the plea agreement between the state and the defense, and upon the state's recommendation, the court defers the finding of guilt, places Ms. Jennifer Paulina Zanella on 10 years deferred community supervision, orders her to pay a $2,000 fine, orders her to pay $290 court costs and $90 in reimbursement fees, and the court dismisses cause number CR 23-156, possession of marijuana, and cause number CR 23-157, resisting arrest, pursuant to section 1245 of the Texas Penal Code. Ms. Zanella, how old are you? 21. You're a young woman. Too young to be having a 10-year felony probation in her life. Have you already learned it that quick?
Yes.
Yeah? Tell me how so. How have you learned it? Why do you think you learned your lesson?
Oh. Everything's cool. I can stay with my baby.
Babies can be very motivating individuals, can't they? You love your baby? Boy or girl? Little girl, how old is she? 6 months. So you're telling me that you're gonna do everything in your power, humanly possible, to not violate a single probation condition so that you can spend as much time with your baby, your little girl, that you want. Is that correct? You understand that the pendulum swings the other way too. If you violate, there's a good chance that you're not going to be able to spend time with your baby. You understand that? And you understand that if you violate any of these probation conditions, that the court would conduct a hearing, and at that hearing, the decision is the decision is not whether or not you committed this crime, but whether or not you violated your probation. You understand that? And you understand also that if you violate and the court has that hearing, the court can do a lot of things, including convicting you of this offense, making you a convicted felon. Do you know how bad a conviction on your record, you know how bad that could be? Do you really?
Pretty bad.
Really bad. I mean, it affects your entire life for the rest of your life. Your ability to get a job,
Yeah.
your ability to get a loan, your ability to be trusted every time you get stopped by law enforcement. They're going to see things like that. Your ability to travel freely in the country after being detained could be very serious. Or it could not only convict you, but could revoke your community supervision and could assess your punishment anywhere from that minimum 2 years all the way up to 10 years in prison. And that would be a very sad thing, wouldn't it, Miss Zanella, to be convicted and to go to prison while your little girl is outside being raised by somebody else? I'm kind of giving you the scare tactic now because I want you to really pay attention to it. I don't want to have this conversation later. And I don't want to be feeling sorry for your daughter if you decide that you're not going to comply. I think that you're going to, but I'd rather have this conversation now than later. You agree? Okay. All right. Ms. Zanella, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted with Deputy Martinez. After that, I want you to report over here to the probation officers and they'll give you more information. Thank you, Mr. Ellison. Yes, sir. I appreciate you being here yesterday. Sorry we couldn't get the lights back on in time to do it yesterday. Have a good day, sir. Well, hey, if Rockwall was shut down, then I felt like there's nothing we could have done about it. All right, of course, going to stand in recess for 20 minutes, allow Mr. Schmidt to meet with his clients. So it's 10:20, so just check back in about 10:40. You're free to move about. I do need a favor, go to that computer over there and start it. No, start the camera. Lower left.
Oh. You.
No, just the camera. All right, Mr. Schmidt, who would you like to call first? Wayne Wingo. This is cause number CR 2467. Is Mr. Wingo a plea today? Just present it, I'll mark it. All right, the court has granted the transfer from the County Court of Law to the 294 District Court for Mr. Wingo's misdemeanor case, cause number 2024-91. We're on record also on cause number CR 24-67. Mr. Wingo, sir, if you'll raise your right hand, I'm going to place you under oath. Do you swear that the testimony you give to the court today would be the truth, the whole truth, and nothing but the truth? So help you God, under the penalty of perjury. Thanks, sir. You can lower your hand. All right, your name is Wayne Allen Wingo, is that correct? And Mr. Wingo, are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with a mental condition? In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work he's done for you? Feel like you've had enough time to talk with him about your case, that you understand everything that you've read and signed? Any questions before we go further? Mr. Schmidt, do you believe Mr. Wingo to be competent? And if so, do you believe that he is entering into this agreement intentionally, knowingly, and voluntarily in each case?
Yes.
All right, Mr. Wingo, in cause number CR 2467, you are charged by indictment with the offense of burglary of a habitation that carries a range of punishment if convicted and sentenced to not less than 2 years in prison or more than 20 years in prison, and a possible fine not to exceed $10,000. In cause number 2024-91, you're charged by information with a Class A misdemeanor offense of assault causes bodily injury of a family member that carries a potential range of punishment of not more than 365 days in the county jail and a possible fine not to exceed $4,000. I see that you've reached plea agreements with the state in each one of your cases. In the burglary of a habitation charge, upon your plea of guilt, the state is recommending that the court review the evidence, not find you guilty, defer a finding of guilt, place you on 5 years of community supervision, ordering you to pay fines, court costs, and reimbursement fees. In the misdemeanor assault causes bodily injury family member, the state's recommending that the court consider the evidence, find you guilty, assess your punishment at 1 day confinement in the Van Zandt County Jail, giving you credit for 1 day of time already served, order you to pay $100 fine plus court costs. Is that your understanding of both your plea agreements, Mr. Wingo?
Yeah.
All right, then in regards to the burglary of habitation, a second-degree felony, how do you plead to that crime? As to assault causes bodily injury of a family member, Class A misdemeanor, how do you plead to that crime? Are you pleading guilty to each one of these crimes because you are in fact guilty of committing each one of these crimes? Has anyone threatened, forced, or pressured you to plead guilty? All right, the court does accept the defendant's plea of guilt in each case respectively. Mr. Schmidt, any objection to the stipulation of evidence?
No.
Stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing for the time.
All right, anything further from the defense? And is the state in compliance with victim notifications?
Yes.
All right, the court's going to review the evidence. All right, the court, having reviewed the evidence, finds that there is sufficient evidence to convict Mr. Wingo of these offenses. However, the court in cause number CR 2467 to the charge of burglary of a habitation, the court defers a finding of guilt, places Mr. Wingo on 5 years community supervision, orders him to pay a $1,000 fine, $290 in court costs, and $555 in reimbursement fees. Court finds that that is pursuant to the plea agreement with the state and at the recommendation of the state of Texas. In regards to cause number 2024-91 on the charge of assault causes bodily injury based on the evidence, the court finds that there is enough evidence to convict Mr. Wingo. The court follows the plea agreement as recommended by the state. The court convicts Mr. Wingo, assesses his punishment at 1 day confinement in the Van Zandt County Jail, orders that he receive credit for time served for 1 day. The court orders him to pay a family violence fee of $100, court costs of $270, and reimbursement fees of $45. All right, Mr. Wingo, you hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted with Deputy Martinez, and then the probation officers will give you information about what's next. Joshua Nowak. This is cause number CR 2365, State of Texas versus Joshua Harley Nowak. Court finds that the state has tendered a motion to dismiss in this case, alleging insufficient evidence. Court is granting the state's motion to dismiss. Mr. Nowak, you're free to go. If you want a copy of this, stay in the hallway and we'll bring you a copy for your records. Mr. Drummond. This is cause number CR 24-50, State versus Edward Joseph Drummond for arraignment. Go ahead, Mr. Schmidt. All right, court finds that Mr. Drummond, having waived the requirements of arraignment, court enters his plea of not guilty into the record. Court sets this matter for pretrial hearing. Do you want that July 2nd date, Mr. Schmidt? Court sets Mr. Drummond for pretrial on July 2nd, 2024 at 9 a.m. And has your client signed his conditions of pretrial release?
No.
All right. You've already done it?
Yes.
All right, Mr. Drummond, if you'll come over here and see Mr. West, once you sign your paperwork, get copies, you're free to go. Heath Weldon Meredith, cause number CR 23164. Mr. Meredith, set for docket call. Go ahead, Mr. Schmidt. All right, court sets Mr. Meredith for plea before the court July 2nd at 9 a.m. Is it a 9 a.m. or a 1:30 plea? 9 a.m. 1:30? All right, court sets Mr. Meredith to enter plea July 2nd at 1:30. Mr. Ettridge. This is cause number CR 11-119, State versus Jeremy Wayne Estridge. I think we're just on financial status. Go ahead, Mr. Schmidt.
That's correct, Judge. Still make progress. Still working down that big restitution amount. He asked for 60-day compliance.
Any objection from state?
No, Your Honor.
All right, court will reset Mr. Estridge. Yeah, I've got a couple of Tuesdays. I've got August 13th, August 27th, 13th. All right, court sets Mr. Estridge for a compliance hearing Tuesday, August 27th at 9 a.m. I've got Mr. Wells here. He's been here. Mr. Page disappeared a couple hours ago. Mr. Wells, can you see and hear me okay?
Yes, sir.
All right, do me a favor, take off your hat for me, okay?
Yes, sir. Sorry about that.
All right, this is cause number CR 17-266, State of Texas versus Robert Michael Wells. Mr. Wells is appearing via Zoom with court approval. And I think we're set today on a status. Mr. Schmidt, go ahead.
Thank you for bringing it over back.
I don't have, at this point in time, we're gonna ask for additional 9 seconds to get to where I can see my guy. Just a 30-day setting on it. July 2nd should be sufficient, if that's okay.
Any objection from the state?
No, Your Honor, thank you.
All right, court will reset Mr. Wells for a compliance hearing on July 2nd at 9 a.m. All right, so Mr. Wells, this is the notice that you're getting from the court. You're due back July 2nd, 2024 at 9 a.m., okay?
Yes, sir.
All right, you're free to go.
Thank you.
You're welcome. All right, so can we announce on Preston Wilson? CR 2383 State versus Preston Mitchell Wilson. You said you indicated that he's in federal custody.
He is in that.
All right,
I had notifications when or how he'll be there, but I suspect it'll be.
does the state have any information?
Your Honor, I don't, or we should have noticed, I can, either the begin on file.
All right, so I'm short on time. Court's going to reset Mr. Wilson for status of federal custody on July 2nd And Mr. Hartwell, before that hearing, if you can just find out if what information you can get from the federal prosecutors and this may impact or not impact your case. All right, Mr. Schmidt, you need to go talk to the rest of your clients. All right, and then let me know if Mr. Page gets logged back in.
Yes.
Mr. Waldron, you ready, sir?
Yeah, we are.
Carrie Lynn Sanders, CR 22392. Apologize about the rescheduling from yesterday and the kind of mix up mornings and afternoons. Apologize about that, but here we are. We're set for pretrial today. Any announcements, Mr. Waldron?
Judge, we would announce not ready. Couple of things on that. Mr. Sanders has a case out of Wood County. That similar time frame that we're also dealing with. The other one is, I've gone through the discovery. There may be a recording that we don't have. I've asked the state to look for it. I believe the state's gonna look for that. I believe this is an agreed pass today, the state of protection.
Yeah, that's correct, Your Honor. We're gonna look and see if we can find, the recording.
Mr. Waldron, can you be back on July 2nd? Yes, sir. All right, court sets Mr. Sanders then for Tuesday, July 2nd at 9 a.m. for an additional pretrial. Mr. Wheeler, are you ready on this swope? All right, can you go ahead and bring me the paperwork? Thank you, Mr. Waldron. Yes. Yeah, free to go after he signs. Swope, if you'll come forward, please. Miss Swope, go this way. Sorry. This is cause number CR 24-66, State of Texas versus Christina Marie Swope. Ms. Swope, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, thank you. You can lower your hand. Your name is Christina Marie Swope, is that correct? And Ms. Swope, are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Jim Wheeler. Are you pleased with Mr. Wheeler and the work he's done for you? Feel like you've had enough time to discuss the case with him and that you understand everything that you've read and signed today. Any questions before we go further? Mr. Wheeler, do you believe your client to be competent? And if so, have you explained to her rights regarding this case and that she's entering into this plea intentionally, knowingly, and voluntarily?
She is competent, Your Honor. I have discussed her rights with her. She has laid up rights and that her plea freely, intelligently, knowingly, voluntarily.
Thank you, sir. All right, Ms. Swope, you are charged by indictment with a first-degree felony offense of theft of property greater than or equal to $300,000. A first-degree felony does carry a range of punishment of not less than 5 years or more than 99 years or life confinement in the Texas Department of Criminal Justice and a potential fine not to exceed $10,000. I see that the proposed plea agreement in your case is that upon a plea of guilt, the state's recommending that the court defer a finding of guilt, not convict you, place you on 10 years community supervision, order you to pay restitution to be determined at a later date, and the state would be asking the court to dismiss a money laundering case, which is unfiled DA 2024-42. In addition, you would have court costs and reimbursement fees. Ms. Swope, is that your understanding of the plea agreement? All right, so as to that charge of theft of property greater than or equal to $300,000, how do you plead? Are you pleading guilty to that crime because you are in fact guilty of committing that crime? And Ms. Swope, has anybody threatened, forced, or pressured you to plead guilty? All right, the court will accept the defendant's plea of guilt. Mr. Wheeler, any objection to the stipulation of evidence?
Okay.
All right, stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing for,
Is the state in victim compliance?
stated in my.
All right. And is the victim in this case supportive of the plea?
Yes, sir.
All right, thank you. Anything further from the defense?
No.
All right, court's going to review the evidence. All right, the court, having reviewed the evidence, finds sufficient evidence to convict Ms. Swope of this offense. Court will follow the plea agreement reached today. The court hereby defers a finding of guilt to theft of property greater than or equal to $300,000, a first-degree felony. The court places Ms. Swope on 10 years community supervision, orders her to pay court costs of $290, reimbursement fees of $35. The court finds that restitution will be determined at a later hearing. Are y'all still working on the restitution issue? I'm just trying to determine how long I need to give y'all before we set that for hearing.
You all work on check messages and diamonds do not want to provide seriously affects not. Once they have that, man.
30 days, 45 days, what do we?
You're right. There's a July on this.
Let's set it for Mr. Wheeler. I want you to check your calendar. Are you available for July 30th? All right, I'm gonna go ahead and set it on the evidentiary docket. That way, if we have to have a restitution hearing with testimony, we'll do it that day. All right, Ms. Swope, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward with Deputy Martinez. He's gonna take your fingerprint. And then we're gonna give you a reset notice for that July 30th date. Mr. Wheeler, is that all you have today, sir?
In this case.
In this county. Off to the next time. Where are you going next?
Yeah.
Smith County. All right. Well, tell them I said hello when you get over there.
Yes. Thank you.
Yes, sir. Good to see you. You're welcome. All right. Oh, Mr. Nash, if you'll come forward. All right, we're on record, cause number CR 22-71, State of Texas versus Kenneth Ray Nash. Court, having reviewed Mr. Nash's affidavit of indigency and request for court-appointed counsel, finds him to be indigent at this time. The court is appointing the Honorable Jonathan Manning to represent Mr. Nash. Mr. Nash, you're already familiar with Mr. Manning, so you need to be in touch with him. And you've already got your conditions of pretrial release, correct? All right, go ahead and sign that. Let's reset Mr. Nash. Today being the 28th. Let's set this for pretrial hearing for Mr. Manning's benefit. Do you know if Mr. Manning, Ms. Abraham, do you know if Mr. Manning's out on vacation or anything in July? Richard, do you know if all right, we're gonna go ahead and set Mr. Nash for Thursday, July 11th for pretrial. All right, state, for the record, this is cause number CR 24-28, State of Texas versus Stephen Arkell Pickron. We show that he is in TDC. So I'm going to reset this case and y'all make a decision on whether or not you want a bench warrant. If you do, make that request to Ms. Taberham. We'll go ahead and we'll reset it for arraignment on July 2nd. If you decide that you don't want him, then just let us know and file your motion to dismiss.
Yes.
Yes.
Mr. Nash was under the impression that he would be back on June the 3rd for jury selection, and I've just told him that.
That's
we
correct.
removed
We're-
him.
We're going to remove you because you got new counsel and you've withdrawn your plea. So we're going to give Mr. Manning an opportunity to get the discovery in the case, become familiar with that, file any motions that he wants. So you don't have to be back here on June 3rd, be back here on whatever date I said, July 11th. Okay? All right, you're free to go. Yes, there he is.
And that's when you're ready with the interpreter.
Okay.
Sorry, sir. I'm sitting outside. I'm going inside my hotel room now.
Okay, yes, sir. I'll tell you what, just turn your phone off and then once you get there, turn it back on, Mr. Page, okay?
Okay, thank you.
You're welcome. I haven't seen an interpreter. And Mr. Schmidt, if you want to, whenever Mr. Page gets on there, if you want to turn that laptop, he'll be able to see you. There's Mr. Vargas. He just looks kind of like a halo. I know that can't be. And it depends on which way you look. Depends on which shoulder you're listening to. I'll give Mr. Page a second to get situated in his hotel room. And our translator is here. So once we get Mr. Page set up, then we'll.
Yes, sir. Can you hear me?
Yes, sir, I can. Can you see and hear me, Mr. Page?
Yes, sir.
Can you see your attorney, Mr. Schmidt? If not, just swipe left or right, and then you'll see him as well.
I see all of you. Yes, sir.
Excellent. Okay. I'm going to go ahead and call the case, Mr. Page. This is cause number CR 19-63, State of Texas versus Evan Andrew Page. For docket call, the record will reflect that Mr. Page is appearing via Zoom today with court permission. Go ahead, Mr. Schmidt.
Additional topic call. But I know that Mr. Page's residence and travel to and from court is quite expensive in the budget, but my intention is to wrap it up and come back next. So you have an additional topic call and court permission as much time as you grant us, so we can get the funds together to travel back to Texas. Hopefully it gets it this next time. Last.
Any objection from the state? How long are you asking for?
Judge, I don't want to push it too far out, but, in first or early state in August would be great.
And you're anticipating a plea on that date?
I hope to have.
All right, my first Tuesday available would be August 13th. All right, Mr. Page, the court is ordering you back here in person in court on Tuesday, August 13th for a docket call, okay?
Yes, sir.
All right, make sure you stay in contact with the pretrial release officer, your bail bondsman, and Mr. Schmidt, okay?
Yes, sir.
All right, you're free to go.
Thank you.
You're welcome. All right, I'm gonna bring in Mr. Vargas. Let's go ahead and bring up your first one, Mr. Schmidt. You want to bring up Funes? Good afternoon, Mr. Vargas.
Good afternoon, Judge.
All right, well, thank you for joining us today. Let me do a couple things and then we're gonna go ahead and get Mr. Funes. That's who we're gonna go with first is Jose Martin Funes in cause number CR 23-126. Mr. Vargas, let me go ahead and get you to raise your right hand. I'm gonna ask that you identify yourself for the record and state your license number. Go ahead, sir.
For the record, my name is Alfredo Vargas, Master Court Interpreter, license number 918 with the Office of Court Administration.
Mr. Vargas, as I administer the oath, do you solemnly swear or affirm that you will make a true translation of the statements of the court, the questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and judgment, so help you God?
I do.
Thank you, sir. All right, let me go ahead and get the translation set up. And once I get this set up, then if you'll go ahead and make contact with Mr. Funes and let me know that everything appears to be working. That's okay. As long as Mr. Schmidt's speaking up, should be okay. Mr. Vargas, can you see and hear Mr. Funes? Okay. I can't hear you, so you may have to get the other microphone too. For him, get that stand microphone right there for Mr. Funes. Mr. Vargas, and I can't hear you, Mr. Vargas. I don't know if you're. Hang on, let me flip over. All right, now let me go. I am in English, yes, sir. I've got you. Excellent. All right, so everything's working well. All right, hopefully that will maintain. All right. This is cause number CR 23-126, State of Texas versus Jose Martin Funes. Mr. Funes, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? You can lower your hand. Is your name Jose Martin Funes? And Mr. Funes, are you a United States citizen? So you're a lawful permanent resident? And do you understand that in this case, if you enter a plea of guilty, that it may have an adverse effect on your legal status within this country? And in this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt as your attorney? Do you understand everything that you've read and signed today? Mr. Schmidt, do you believe Mr. Oh, I'm sorry. I'm sorry, Mr. Vargas. I'm moving ahead. Go ahead. All right, and Mr. Schmidt, do you believe Mr. Funes to be competent today?
I do.
And you've explained to him his rights as they pertain to this case, is that correct?
I have.
And did you utilize a Spanish interpreter in explaining the paperwork to Mr. Funes so that he could understand it?
No, sir, I did not. Mr. Kuhn does speak sufficient English to understand and communicate with me effectively on the paperwork. I did utilize him in discussing the paperwork with the code.
Does Mr. Funes need the assistance of Mr. Vargas at this time?
I think that he probably would manage without, but in the abundance of caution, I appreciate continuing.
Okay. All right, Mr. Funes, you are charged by, well, let me ask before I go further, Mr. Schmidt, did you discuss the possible immigration circumstances and consequences that could flow from Mr. Funes in his entering a plea to this charge today?
Judge, in the onset of my representation, as Mr. Funes discussed the immigration potential consequences in writing and verbally, as well as recommended that he seek out from the immigration attorney that he was concerned about.
And do you believe he understood your admonishments and advice? All right, is that true, Mr. Funes? Do you understand the advice that Mr. Schmidt gave you regarding possible immigration circumstances and consequences? All right, then, Mr. Funes, you are charged by indictment with a third-degree felony offense of theft of material comprised of either aluminum, bronze, copper, or brass, less than $20,000 in value. I see the plea agreement in your case is that upon your plea of guilty, the court would be asked to defer a finding of guilt, place you on 3 years of community supervision, fine you $750. You would be responsible for court cost of $290 and reimbursement fees to Van Zandt County for $535. And the state would be dismissing and engaging in organized criminal activity charge to which you have not been indicted. Do you understand that? And Mr. Funes, the range of punishment for this charge is not less than 2 years in prison or more than 10 years in prison. If the court approves this agreement and you violate your probation, the court may have the ability to revoke your probation and sentence you anywhere from that minimum of 2 years up to a maximum of 10 years. Do you understand that? All right, Mr. Funes, at this time, I would ask you, how do you plead to the third-degree felony offense of theft of material, precious metals, aluminum, bronze, copper, or brass, less than $20,000? Guilty or not guilty? And Mr. Funes, are you pleading guilty to that crime because you are guilty of committing that crime? Mr. Funes, has anybody threatened, forced, or pressured you to plead guilty today? All right, the court accepts the defendant's plea of guilt. Mr. Schmidt, is there any objection to the stipulation of evidence?
No.
All right, the stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
No.
Is there anything further from the defense?
No.
All right, the court's going to review the evidence. All right, the court finds that there is enough evidence to convict the defendant of this offense. The court will follow the plea agreement and the recommendation of the state of Texas. The court hereby defers a finding of guilt, places Mr. Jose Martin Funes on 3 years community supervision, orders him to pay a $750 fine, $290 court cost, $535 in reimbursement fees, and the court dismisses engaging in organized criminal activity, unfiled case DA 2023-0381. Mr. Funes, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm going to have you come forward to be fingerprinted with the bailiff, Deputy Martinez. After that, you'll need to meet with the probation department to go over your paperwork. Do you have any questions, sir?
Oh,
All right, thank you, sir. If you'll,
thank you, sir.
you're welcome. Luis Funes Rivera. And Alfredo, I believe the plea agreements are going to be the same in all of these cases. So all the terms appear to be the same. So that should make it somewhat easier. All right, let's get Mr. Yeah, we're going to check him. I can't hear you. All right, excellent. All right, this is cause number CR 23127, State of Texas versus Luis Miguel Funes Rivera. The court finds that Mr. Funes Rivera is not a primary English speaker. The court has sworn in Mr. Alfredo Vargas as the court interpreter. Mr. Funes, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You can lower your hand. Is your name Luis Miguel Funes Rivera? And Mr. Funes Rivera, are you a United States citizen? And Mr. Funes, do you understand also that if you enter a plea of guilty to the court today, it may affect your legal status within this country? And you've had an opportunity to discuss this issue with your attorney, Mr. Schmidt, regarding possible immigration circumstances and consequences, but you understand that Mr. Schmidt is not an immigration attorney? Mr. Funes, have you ever been diagnosed with any type of mental condition?
Oh,
All right, Mr. Schmidt is your attorney. Are you pleased with Mr. Schmidt and the work he's done? Do you understand everything that you've read and signed today in your plea agreement? All right, Mr. Schmidt, do you believe your client is competent today?
yes,
And Mr. Funes Rivera is also a Spanish speaker. Were you able to enlist the services of anyone to explain these documents to him in his native language?
representation of utilized Spanish interpretation.
He can't hear. I'm sorry, Mr. Schmidt, he can't hear you. Yeah, the interpreter.
Yes, throughout representation of utilized an interpreter to make sure that all the legal consequences of, these actions are made clear to them. You know, in addition to that, I utilized the planning commission today, and confident to go through, the paperwork and the consequences. I believe they understand, fully.
All right, Mr. Schmidt, can you just come forward? Bring the microphone with you and just, if you'll come here and leave him there. I'm going to repeat for the record, Mr. Schmidt has indicated that he has utilized translation services during his representation. I believe you're still in the English. I think you're still in the English, Mr. Vargas. I'm going to repeat what Mr. Schmidt said. I'm going to paraphrase Mr. Schmidt. Correct me if I'm wrong. Mr. Schmidt indicated that during his representation of Mr. Funes, he's used translation services to explain the paperwork and consequences of entering into a plea agreement. And then today in court, he utilized the assistance of a co-defendant who was also bilingual to help convey the meaning of the plea agreements today and the paperwork and the legal consequences, and that Mr. Schmidt believes that Mr. Funes Rivera understands the paperwork.
That's correct.
All right, and Mr. Funes, you are charged by indictment with a third-degree felony offense of theft of precious metals or materials composing of aluminum, bronze, copper, or brass less than $20,000 that carries a range of punishment of not less than 2 years in prison or more than 20 years in prison. I'm sorry, not less than 2 years in prison or not more than 10 years in prison, and a possible fine not to exceed $10,000. The plea agreement in your case is that upon your plea of guilty, the court is understanding the recommendation of the state to be that Mr. Funes Rivera not be convicted, but he be placed on 3 years of community supervision with a $750 fine, $290 court cost, and $535 in reimbursement fees. And the state is recommending that the engaging organized criminal activity charge for Mr. Funes Rivera be dismissed upon his plea of guilty in this case. Mr. Funes, is that your understanding of the plea agreement? Mr. Funes, how do you plead to that crime? Guilty or not guilty? And Mr. Funes, has anybody threatened, forced, or pressured you to plead guilty today? All right, the court accepts the defendant's plea of guilt. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
All right, the stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, thank you.
Anything further from the defense?
No, sir.
All right, the court, having reviewed the stipulation of evidence, finds that there is enough evidence to convict the defendant. The court this day follows the plea agreement and the recommendation of the state. The court defers the finding of guilt for Mr. Luis Miguel Funes Rivera, places him on 3 years community supervision, orders him to pay a $750 fine, $290 court cost, and $535 in reimbursement fees. The court also dismisses under section 1245, engaging organized criminal activity, unfiled, unindicted, DA 2023-0379. Mr. Funes Rivera, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm going to have you come forward to get fingerprinted. After that, you're to meet with the probation department and go over your probation paperwork. Do you have any questions, sir? All right, thank you, sir. If you'll come forward to be fingerprinted. Mr. Rodriguez. All right, Mr. Vargas, next up is going to be Lesky Rodriguez Miranda. Just a typo.
It must very well be. Yeah, these have never been in
No,
CCS.
I think you did that on purpose.
Yeah. Not my style. I'm far more soft.
Uh, mm. All right, Mr. Vargas, are you able to communicate with Mr. Rodriguez?
Hey,
Excellent. All right, this is cause number CR 23-131, State of Texas versus Lesky Rodriguez Miranda. Mr. Rodriguez, if you'll raise your right hand, I'm going to place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
no,
Okay. Thank you, sir. You can lower your hand. All right, Mr. Rodriguez, are you a United States citizen?
No.
Are you a lawful permanent resident?
No.
Do you understand, Mr. Rodriguez, a plea of guilty in this court today may have an adverse effect on your status within this country?
say,
And in this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the legal work he's done for you?
say,
Do you understand everything that you've read and signed today in your plea agreement?
say,
Mr. Schmidt, do you believe your client is competent, that he understands the potential immigration circumstances of a plea of guilty, and that he's entering into his plea agreement intentionally, knowingly, and voluntarily?
Judge, I do believe he is competent. I have explained in writing and verbally through a translator the potential immigration consequences involved with his plea. I've also made it clear to him that I am not a qualified immigration attorney, and that if he is concerned about those issues, that he should seek counsel specifically pertaining to the immigration consequences. I do believe he understands the nature of his plea, and we're ready to proceed.
All right, Mr. Rodriguez, you are charged by indictment with theft of precious material, aluminum, bronze, copper, or brass, less than $20,000. That does carry a range of punishment of not less than 2 years or more than 10 years in prison, and also carries a potential fine of not to exceed $10,000. The plea agreement in your case is that you plead guilty. The state's recommending that the court not convict you, but place you on deferred community supervision for a period of 3 years. Also ordering you to pay a $750 fine, $290 court cost, and $535 in reimbursement fees. Is that your understanding of the plea, Mr. Rodriguez?
hey,
And Mr. Rodriguez, have you had the paperwork explained to you in your native language of Spanish?
say,
All right, so Mr. Rodriguez, then how do you plead to that third-degree felony offense of theft of precious metals? Guilty or not guilty? And Mr. Rodriguez, has anybody threatened or forced or pressured you to plead guilty today?
no,
All right, the court will accept the defendant's plea of guilt. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
All right, the stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
Your Honor, for clarification, I guess, it's the court, no. The fourth vote that Mr. Jose Sosa, was also not legal in this country. Those reasons that we are the plea to the charge and they're giving credit to the time to serve the custody. So with that heard, Mr.
Rodriguez.
May not.
Oh, and they're kind of-
Well, here, you're gonna have to, you're gonna have to come this way or he can't here.
I was unclear on that matter as well, but ultimately it's her issues. You know, he was in custody, bonded out. I chose not to initiate anything for whatever reason. So I get to look at the drawing, Mr. Jose Sosa, and he's been deported. So under the circumstances, it is what it is.
I just didn't want at some point for that to come back on our office and say, well, you granted probation to someone who's not. Fact of the matter is, I wouldn't be fresh in it.
Well,
We can let me go forward with Mr. Schmidt's representation, the high school not being placed on his account. But I just want to put that.
Okay, thank you.
we understand.
Okay, anything further from the defense?
No, sir.
All right, then upon review of the evidence, the court finds sufficient evidence to convict Mr. Rodriguez of this offense. The court follows the plea agreement today between the state and the defense. The court defers a finding of guilt, places Mr. Lesky Rodriguez Miranda on 3 years community supervision, orders him to pay a $750 fine, $290 court costs, and $535 in reimbursement fees. And the court dismisses engaging in organized criminal activity, case DA 2023-0377. Mr. Rodriguez, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm going to have you come forward with Deputy Martinez. He's going to take your fingerprint. After that, you need to meet with the probation officers through this door so that they can go over your probation paperwork. Do you have any questions, sir?
No.
All right, then we're adjourning this hearing. All right, and so Mr. Schmidt, you're indicating that Mr. Manzanares was deported?
No, sir, that is not my understanding. I believe he is a resident. This is of Houston. And I have not had direct communication.
He just didn't appear today.
I think it's just a different.
All right, do you have anything else, Mr. Schmidt? Who's this gentleman? All right. Yes, correct. Huh?
They're telling you hold off, start working in this one.
Let's finish one more. No, Mr. Vargas, I do think that does conclude our need for you today. I appreciate you being here. Thanks, sir. Yes, sir. Have a good day. Yeah, he's calling them right now. He's calling them. All right, for the record, cause number CR 2438, State of Texas versus Cynthia Joyce Warrington. Ms. Warrington did not appear today as ordered by the court. Her name has been called loudly, distinctly 3 times in the courthouse with no response. Court hereby issues a judgment nisi and alias capias and issues new bail in the amount of $200,000 cash or surety. One more. For the record, cause number CR 23130, State of Texas versus Lazo Daniel Manzanares. Mr. Manzanares, his name was, he was set on the docket today. He failed to appear as ordered. His name was called loudly and distinctly 3 times in the courthouse without a response. Court hereby issues judgment nisi and alias capias and issues bail in the amount of $100,000. Have you met with Mr. McDonald? Have you met with Mr. McDonald? Okay, she wrote on me. So anytime that they write papers to sign, if you want to grab them beforehand and get all that done before I call them or after, that's fine. That way you're not held over waiting.
No.
All right, court calls, cause number CR 23-151, State of Texas versus Jason Wayne McDonald for pretrial. Go ahead, Mr. Schmidt. All right, court sets Mr. McDonald for docket call July 2nd at 9 a.m. Mr. McDonald, once you sign and get your notice of setting, you're free to go, but I want you to come over here and meet with Mr. West to sign your conditions of pretrial release. All right, that does conclude this morning docket. Court will resume at 1:30 on the jail docket. Court's in recess.